Everyone. Today we are going to be discussing the article Amending the Americans with Disabilities Act, Shifting Equal Opportunity Obligations in Public Human Resource Management by Christine Ledvinka Rush. One of the court cases that this paper opens with is Albertson versus Kirkenberg. This narrowly defined who would be considered disabled under the Americans with Disabilities Act. Congress responded by amending the Act to return to the more broad definition. Question at hand is, how can public employers best respond to changing ADA obligations? ADA is intended to be an anti-discrimination statute that is broadly defined. Human resource managers have an obligation to adhere to ADA. One of the main intentions of ADA was to assist with the high rate of unemployment for people with disabilities. The ADA defines a disability as a physical or mental impairment that sustainably limits one's life activities. It is the employer's responsibility to create a reasonable accommodation. This should not require the employer to engage in excessive hardship. The terms of the ADA eventually went to court to determine who would be eligible. In Murphy versus the United States Parcel Services, it was limited who could be included in the definition of disability under ADA. Congress created amendments that backstepped the limitations on the definition of diversity established under Sutton versus United Airlines. This case determined that vision impairment was not a protected disability. Toyota Motor Manufacturing versus Williams refused to consider carpal tunnel syndrome and other stress impairs as a protected disability. Congress stated that employers' focus should be on providing an accommodation rather than on disproving a disability. Employers should always seek to provide a reasonable accommodation, regardless of the analysis of a request, if a request is a, quote, real disability. They changed the definition of disability from sustainably impaired to significantly restricted. The goal of the EEOC guidelines was to create some flexibility in who could qualify as having a disability. Employers should see understanding the ADA as an essential part of following it. With the vague definition of disability, it can be challenging to understand who fully qualifies for the Act while also keeping costs in mind. The vague wording may have created an even greater need for judicial interpretation. Impairment does not need to limit more than one major life function to clarify as a disability. The new definition is only applicable to actions that took place after the law was passed. Individual state officials can be determined liable for money damages for violations of ADA. Some employers are waiting for judicial interpretation on ADA. The Amendments Act suggests that employers develop a team to analyze current company policies regarding ADA and suggest improvements. Effective training can improve adherence to ADA. Companies that use collaboration are more likely to effectively comply to ADA standards. Employers should strive to create a culture of ADA adherence. Thank you.